Right. Good morning, class. Settle down immediately, please, and take out your notebooks. Today, we're covering a fundamental, absolutely indispensable topic in family law too, Muslim law. Specifically, we'll be dissecting dower, or mehr, and the widow's right of retention. Now pay absolute attention to this lecture, because this right here is a guaranteed 16-mark question in your KSLU final examinations. If you master the exact structure I'm giving you today in this explainer, those 16 marks are literally sitting right in your pocket. Let's begin.
Here is your blueprint. 1. Introduction and definition. 2. Nature of legal obligation. 3. The kinds of dower. 4. Widow's right of retention. And 5. Landmark case law analysis. Write down your first primary heading right in the center of the page. Section 1, Introduction and Definition. Underline it.
Dower, or mehr, an essential incident of marriage, Nikah. It is a sum of money or property which the husband is bound to give to the wife as a mark of respect. Okay, class, I want you to underline the terms essential incident and mark of respect. Under Islamic jurisprudence, Nikah is a civil contract, and dower is the consideration for that contract. But listen to me very carefully here. Do not make the fatal, unpardonable mistake of confusing mehr with the Hindu concept of dowry. Dowry is a social evil extracted from the bride's family. Mehr, on the other hand, is a fundamental legal obligation placed squarely on the husband to honor and respect the wife. You must write that precise distinction clearly in your introduction. Now we move to the formal jurisprudential definition. Note this carefully on your screen. Dower is a sum of money or other property which the wife is entitled to receive from the husband in consideration of marriage. This definition is by Mulla. In a law exam, an answer without an authoritative juristic definition is simply incomplete. You must memorize Mulla's exact words, put them in double quotation marks, and write, according to Mulla, in bold, underlining the author's name. That instantly captures the evaluator's attention and signals that you've actually studied the standard authoritative text. Move to your next major heading, Section 2, Nature of Legal Obligation. Again, structure is everything. Nature of dower. Legal obligation, not a gift. Right of the wife. Can be recovered like a debt. Present this section exactly as bullet points on your exam. Let me dissect that third point for you, because recovered like a debt is the absolute core of her legal remedy. If the husband defaults, the wife doesn't beg for charity, right? She files a civil suit for the recovery of a debt. It stands on the exact same legal footing as an actionable, unsecured debt. When you write your answer in the exam hall, draft these points vertically. Evaluators just don't have the time or patience to hunt for your key points hidden in dense paragraphs. Next heading, Section 3, the kinds of dower. Pay attention, because this classification section is exactly where examiners look for your correct usage of Arabic terminology. Prompt dower or muwajjal, payable immediately on demand. Wife can refuse cohabitation until paid. Versus deferred dower or muajjal, payable on dissolution of marriage, either death or divorce, acts as security for wife. For your exam paper, I strongly advise you to draw a physical line down the middle of your page to compare these two types, just like this. Notice the spelling of muwajjal versus muajjal. Prompt dower is immediate, and crucially, she can literally refuse cohabitation until it's paid. Deferred dower acts as a future security. Distinguishing between them clearly in a tabular format will absolutely fetch you maximum marks here. Proper dower, or Mahr-i-Misl, fixed by law when not specified, determined by wife status and family customs. Specified dower, or Mahr-i-Misl, fixed by agreement at time of marriage. This is the second set of classifications. Proper dower comes into play by operation of law when it wasn't explicitly specified at the time of the contract. Specified dower is just the amount agreed upon up front. Make absolutely sure you note down and memorize the Arabic terms Mahr-i-Misl and Mahr-i-Misl accurately. A good law student speaks the precise language of the law. Heading number 4, Section 4, Widow's right of retention. We now transition to the second major limb of your 16-mark question. Meaning, Step 1, marriage dissolves. For example, husband's death. Step 2, dower debt remains unsatisfied. Step 3, widow retains possession of deceased husband's property until satisfied. This right unfolds in distinct, chronological steps. When you explain this meaning on your answer script, do not just write a bulky paragraph. Break it down into these exact, logical steps. It demonstrates immense conceptual clarity. You're basically proving to the evaluator that you understand the precise sequence of legal triggers required for this specific right to manifest. Features: it is a possessory right, not ownership. Applies only when possession was obtained lawfully. Widow cannot alienate property. Let me severely warn the class right now, when you write possessory right, not ownership on your paper, you must write not ownership in bold or capital letters. Underline it twice. The widow is merely holding the property as a security, much like a bailee or a pledgee. She doesn't magically acquire the title. Therefore, alienation, which means selling, gifting, or mortgaging the property, is strictly forbidden. If she sells it, she violates the law, and the sale is voidable. Do not miss this critical distinction.
Purpose. It protects the financial interests of the widow and ensures the payment of the dower. Establishing this legislative intent acts as the perfect, logical bridging paragraph in your essay. It tells the examiner exactly why the law created this protective mechanism before you jump into how the courts have actually interpreted it in practice.
Finally, Section 5, Landmark Case Law Analysis. I've said it 100 times in this class, and I will say it again. A law answer without case law is an empty vessel. It will ring hollow to any KSLU evaluator. Abdul Qadir v. Salima recognized dower as a legal obligation arising out of marriage. Write this case name in a separate, clear, boxed format on your paper. Let's do a deep dive. The brief facts here involved a husband trying to enforce restitution of conjugal rights without having actually paid the prompt dower. The final ratio decidendi, the binding verdict of the court, was crystal clear. The wife's right to prompt dower is an absolute condition precedent. She can rightfully refuse herself to her husband until that dower is paid. So what's the absolute relevance of this case? It matters because it conclusively proves that mehr is an inherent, inescapable duty attached to the marriage contract itself, not a mere afterthought. Underline this citation to instantly capture the evaluator's attention. Hamira Bibi v. Zubeda Bibi recognized widow's right of retention until dower is paid. Pause and absorb this. This is the definitive Privy Council authority you absolutely must cite for this 16-mark answer. The brief facts revolved around a widow lawfully holding on to her deceased husband's estate while the other legal heirs aggressively demanded their share. The ratio decidendi of the court cemented the right of retention. The court held that if the widow has lawfully and without force or fraud obtained possession of her husband's property in lieu of her dower, she is absolutely entitled to retain that possession against the other heirs until her dower debt is completely discharged. Its absolute relevance lies in establishing that possessory right feature we discussed earlier. Instruct your pens to underline Hamira Bibi emphatically. Conclusion. Dower is an essential element ensuring financial security. The widow's right of retention strengthens this protection, allowing her to hold property until dues are satisfied. Now, never let your answer script end abruptly, immediately after your case laws. An abrupt end guarantees lost marks. This exact paragraph neatly ties the two core concepts, the fundamental obligation of dower and the protective remedy of retention, together, summarizing the absolute essence of the law. Before I dismiss the class, read this question on the board. If dower is a mandatory legal obligation, how effectively does the right of retention protect a widow if the deceased husband leaves behind zero physical property? Think about it. The right of retention is purely a possessory right. But what if there's literally nothing physical to possess? Does the law fail her then? I challenge you to think beyond the printed syllabus for your future legal careers. Ponder over the limitations of possessory rights. Prepare your notes exactly as we've outlined today, replicate the structure, and you will secure maximum marks. Class dismissed.